Hello, I'm Arthur Hardy Doubleday. If you are an adult suffering from lead poisoning due to a landlord's negligence, you might think you have no legal recourse. There is a persistent myth in Massachusetts that lead paint laws are designed only to protect children, and therefore adults don't have a case. I'm here to tell you that is false. While the legal path is different and certainly more demanding than it is for a child, you absolutely can sue for lead paint exposure. You have powerful rights under common law and consumer protection statutes to hold a negligent landlord accountable. Today, I'm going to walk you through the map and the tools we use to fight this battle. To understand your case, you have to understand the law. In Massachusetts, we have two drastically different paths to justice. For children under 6, the law offers a strict liability superhighway. Liability is automatic. You don't need to prove the landlord knew about the lead or was negligent. But as an adult, you are on the common law mountain path. This path requires us to prove the landlord was at fault. We must establish 4 things: duty, breach, causation, and damages. The biggest hurdle on this path is proving that the landlord knew or should have known about the hazard. Why take this path? Because the danger is real. Lead poisoning isn't just a childhood issue. It is a serious adult disease. Exposure can lead to cardiovascular damage like hypertension and heart disease. It causes neurological effects like memory problems and mood disorders. It can damage your kidneys and cause severe reproductive harm. For pregnant women, the risk is exceptionally dangerous as lead crosses the placental barrier, threatening the developing fetus. So how does this happen to adults? Usually it starts with a renovation. Stable lead paint is often manageable, but the moment a landlord or an uncertified contractor disturbs that paint without proper containment, violating EPA rules, they create a toxic dust cloud. This dust settles on your furniture, your dishes, and your clothes, leading to acute, high-level poisoning. This is often the flashpoint of a legal claim. The climb is steep, but your toolkit is deep. We use legal theories like negligence, breach of implied warranty of habitability, and constructive eviction. Your first tool is proving negligence. Under the standards set in cases like Alziab v. Morgus, we must show the landlord had reason to know lead was present. We do this by gathering evidence: prior inspection reports, texts you sent complaining of peeling paint, or the fact that the building was built before 1978. Perhaps your most powerful tool is Chapter 93A, the Consumer Protection Act. Because renting an apartment is a business transaction, landlords cannot engage in unfair or deceptive practices. If they fail to provide federal lead disclosure forms, hide inspection reports, or authorize unsafe renovations, they are violating this law. The penalty? Up to 3 times your actual damages, and the landlord must pay your attorney's fees if you win. To win, we need proof. We need to document your injury through blood lead testing and medical records. We need to document the hazard with date-stamped photos of peeling paint and renovation dust. If we succeed, you can recover damages for medical expenses, lost wages, pain and suffering, and even the loss of the quiet enjoyment of your home. If you suspect exposure, you must act immediately. Protect your health. Get a blood test now. Document everything. Save every text and email. Call a lawyer. The clock is ticking on the statute of limitations. Lead cases are complex and time-sensitive. Evidence disappears, and landlords will try to remediate the proof away. You don't have to make this climb alone. Holding a negligent landlord accountable protects you, but it also sends a message that tenant safety cannot be ignored. Contact Doubleday Law. Guidance and protection. It's what we do. Let's evaluate your situation together.